If you are not legally protected in your business, you are leaving money on the table. Hey, I get it. The legal side of business can feel intimidating, but the good news is it doesn't have to be. If you want to build your business on a strong foundation, and if you want to know that your rights are protected when the unexpected happens with a client or a customer, then it's time to get legally protected. This means no more using free contracts that you downloaded off of the internet. This means partnering with a law firm that actually believes in your vision and can help you achieve it. This means legally protecting your brand so that no one can steal your good ideas. There are a lot of ways to grow and scale, but if you want to grow a strong business, it's time to get legally protected. If you're listening and resonating with this, then my signature service, the Legal Upgrade, just might be perfect for you. The Legal Upgrade is a straightforward, structured process to give your business the legal protection that it needs to thrive. Click the link in the show notes and schedule a call with me today. Hello and welcome to the Legal Upgrade Podcast. I'm your host, licensed attorney Christian Hammond. This podcast breaks down the legal side of business to reveal key legal strategies that can help you take your business to the next level. Please note that none of the following is legal, tax, investment, financial, or medical advice. Without further ado, let's get into the show. Today, we're talking about advertising and specifically what happens when you want to use somebody else's content or intellectual property in your ad. Do you have to ask for permission or can you just do it? Advertising is important for all businesses, whether you do advertising the really traditional way through TV or whether your advertising is more organic and informal. Regardless of how you do it, advertising is important for all businesses, which is why we are taking it on as a topic today. Now, if you are new here, welcome. My name is Christian Hammond. I'm a licensed attorney based in Washington, D.C., but serving clients worldwide, and I specialize in copyright law, trademark law, and helping companies to legally protect their brand, their ideas, and their products. And again, today we are talking about advertising, which is something that all of us do regardless of how we do it, whether we do it in a very informal way or a very formal way. All of us do some type of advertising. And so today we're talking about, well, what happens if you want to use somebody else's brand or somebody else's product in your own advertising? And I want to ask you guys, have you ever recognized yourself, your business, or one of your products in an ad or a video and thought to yourself, I did not approve that. I did not give permission for this. Well, I have. This has happened to me. This was a few years ago. And if you know the musical artist Janelle Monáe, this was a few years ago. And Janelle Monáe had just dropped a new music video. And one of my friends reached out to me. I do not remember which friend it was. If it was you, let me know and remind me. But one of my friends reached out and was like, hey, I think you're in the new Janelle Monáe music video. And I was like, no, I'm not. I have not been in any music videos. There's no way. But I clicked the link that they sent me, and sure enough, there I was, right there in the music video. And it wasn't just me, it was myself and then some of my old classmates. It was a video of us swag surfing at our law school graduation. And so I did not give permission to be in that music video, to be a part of that music video, but there I was, right there on YouTube. And so being a lawyer, people asked me, oh my gosh, what are you going to do? Are you going to sue Janelle Monáe? And I told them, no, I'm not going to sue. I'm not going to sue. And here's why. The question in my situation and in any situation is always, what would I be suing for? What would be my legal claim? Would I be suing for a violation of my right to privacy? Well, the general rule when it comes to the right of privacy is in order to have a legal claim, you need to have had what we call a reasonable expectation of privacy in the first place. What that means is that if someone secretly films you in the privacy of your own home where you thought you were behind closed doors, that's a violation of your right to privacy. Why? Because in your own home behind closed doors, you have a reasonable expectation of privacy because you're in the privacy of your own home where you pay the mortgage or you pay the rent. Now, in my situation, I was at a law school graduation. The graduation was outside. It was accessible to anyone who might have walked by. And it was covered by the press. There were some reporters there. They were taking pictures. They were taking video. That's probably how they got this video in the first place. It probably came from one of those reporters or from one of those news stories. So in this situation, I did not have a reasonable expectation of privacy. I was at a semi-public event outside, and I knew for a fact that there were reporters there taking pictures and taking video. So I, so no reasonable expectation of privacy. So no, this video clip was not a violation of my privacy rights. But let's move on. Let's consider other options. Okay, so maybe it was a violation of my copyrights. But the rule for copyright is that the person who makes the creation, whether it's a photograph, whether it's a piece of music, a book, a tweet, or in this case, a video, the person who makes the video is the one who owns the copyright. So even though I'm in the video, I'm the person who was videoed at my law school graduation, I did not create the video. I was not the person behind the lens. I was not the person who pressed record. So I actually don't own any copyright in that video. So no, it was not a violation of my copyrights. Really, the only thing that maybe I would have had to stand on would be a violation of my right of publicity. Now, right of publicity is basically the idea that all of us have a right to control how our likeness, our image, our voice, our signature, etc., our name, how our likeness is used for commercial purposes. So, arguably, there was a violation of my right of publicity. But here's the thing: right of publicity complaints are difficult to bring because there is no federal right of publicity law, which means these laws are at the state level, which means there are 50 different versions of these laws. So, in order to be successful in a right of publicity claim, I would need to be able to bring it in a state where it would actually be a viable argument. And these laws are different state to state. In some states, you can only bring a right of publicity claim if you are a kind of public, well known figure or a celebrity. In other states, you would need to actually be able to show damages to bring that kind of claim. And honestly, the 2 seconds of me in that video, there weren't really any damages to me. There was no real damage to me for those 2 seconds in the video. So, a right of publicity claim in this case probably would not have been worth the effort. And also, it just so happened that I personally enjoyed the music video and I personally enjoyed seeing myself in it. So, for all of those reasons, no, it was not worth my time. It was not worth my money. It was not worth my effort to sue Janelle Monáe for putting me in her music video without my permission. Now, not all stories end the way my story that I just told you ended. And this brings us to our case study for today, the lawsuit that actually inspired this episode, which is a case where Atari, the video game company, is suing State Farm, the insurance company. And I have to give you a little background on the situation here. So, I think probably everyone here is familiar with Atari and is familiar with State Farm. But what you might not know is that State Farm has been investing pretty heavily in the gaming space. Now, people think that State Farm, what they're really doing here is they're playing the long game. You know, they're trying to get that brand recognition among that younger audience. They're trying to target those individuals who aren't quite old enough to be buying insurance yet, but they're only a few years off, so they're trying to cultivate that brand recognition. They're trying to cultivate that positive association. They're trying to target their next generation of customers. That's what people are saying, that this is the motivation behind State Farm investing in this gaming space. And they've had advertising campaigns around it. They have a full-blown series on Twitch. It's called Gamerhood. It's a gaming competition series. I think it's on I think the third season just happened. So they've invested pretty heavily in this space. And as part of this investment, last year, they ran a 6-second ad. And that ad featured, kind of in the center of the shot, you could clearly see one of Atari's arcade games. Now, it gets even more interesting. So, if you play arcade games, or if you've ever played arcade games, you know that they're in these pretty big, large machines. They're called cabinets. They call them cabinets, and you also know that these cabinets have artwork on the outside of them, and the artwork is custom to that game. It usually has artwork on the side, and it will have the characters for the game. It might have some of the scenery from the game. If you're familiar with arcade games, then you can imagine in your mind what an arcade game cabinet looks like. Well, they used one of Atari's cabinets, and it was from one of their games called Crystal Castles. It's a game that was released in the 80s. If you are a long-term Atari fan, you might be familiar with that game. But what's interesting is that even though they used an actual Atari, or it looks like they used an actual Atari cabinet, they actually changed the top of it. So the top of an arcade game cabinet is usually where the name of the game would go. But instead of saying Crystal Castles, they changed it so it would say Witch's Broom. Now, I don't know how they did this. I don't know if they photoshopped it. I don't know if that's something that happened in post-production, or I don't know if they just kind of brought a cover to the set and just literally covered it up for the while they were filming. I don't know how they did this exactly, but for whatever reason, they covered up the name Crystal Castles, and instead it had the name Witch's Broom. Now, being a lawyer, of course, I have my own theory about why this happened, and I'm guessing that somebody came up with the idea for this ad, and somebody on the legal team was like, okay, we can do this, but we can't use the name Crystal Castles. That is a trademark issue, so cover up the name and call it something else. I don't know how it went down, but that's my guess on how this went down. But even though they covered up the name, when this ad came out, Atari fans still recognized it as Crystal Castles. Why? Because they recognized the artwork that was still on the outside of the cabinet. So they had covered up the main name, but they had changed nothing else about the cabinet itself. The art was still clearly displayed. And again, if you play arcade games, then this is probably not surprising to you. If I saw the arcade game Pac-Man, even if the name Pac-Man was covered up, I would still know it was Pac-Man because I've played a lot of Pac-Man in my life. And in fact, I would like to say I am pretty darn good at Pac-Man. So I would recognize it even if the name was covered up. As a sidebar, shout out to all the old school Atari games like Pac-Man, Pong. I used to love Pong, guys. All right, I'm getting distracted. But if you play arcade games, then you would recognize the cabinet for your favorite game, you would recognize the artwork anywhere, right? And this is exactly what happened. So even though it was covered up, or even though they changed the name to Witch's Broom, Atari fans instantly recognized that it was actually Crystal Castles. And this ad actually kind of got ripped online. People kind of talked about it on Reddit and were like, ew, this ad is so cringe. Why would State Farm do this? So this ad got some negative reception. And Atari responded, and they didn't just sue State Farm, because no, State Farm had not gotten Atari's permission. So they did not just sue State Farm, they actually also sued the marketing companies that had helped State Farm to make the ad. So, word to the wise, if you are a marketing firm and you are putting together an ad that has intellectual property in it that does not actually belong to your client, um, word to the wise that you could find yourself involved in a lawsuit as well, and not just your client. So Atari, again, they sue State Farm. They also sue the marketing companies that helped State Farm put together the ad. And they sued for a laundry list of things, everything from unjust enrichment to false advertising, copyright infringement, on and on and on. But by the time the dust cleared, the court said there was only one claim that really had viability, and that was the copyright claim. So this case is still going. We will have to see whether they decide to settle or whether they decide to go all the way to trial. But the question, as always, that I want to talk about is, what does this mean for you? What does this mean for your business? What does this mean for your company and your own advertisements? And maybe you do advertising in the very traditional sense where you're running ads on TV and you've kind of made all the decisions about what's going to be in there and what it's going to look like. Or maybe you're doing advertising that's much more organic, much more informal. Maybe you are partnering with influencers. So maybe you're not even making that content. Maybe you're reviewing it before it goes out, but maybe you're actually letting somebody else who's not even an employee at your company make advertising content if you are partnering with influencers or doing other type of collaborations like that. So what does that mean as you are making advertisements in your company? And how can you navigate and hopefully mitigate the risk as you're making these different creative decisions, but also, advertising decisions as you're trying to put together ads that are going to be compelling and relevant and engaging? And maybe you're like State Farm and you're trying to engage that next audience. Maybe you're trying to engage your next generation of customers, or maybe you're simply trying to expand outside of the target audience that you now have. But regardless of what your goals are, what does this mean for you, and what does it mean when you're putting together these ads? Well, to begin to answer that question, I think we have to start with, why did Atari sue State Farm in this situation? Lawsuits are very expensive, very time consuming, very resource intensive. And so why did Atari decide that it was worth their time, worth their effort, worth their money to bring this lawsuit? Now, of course, this is just going to be my own personal take. This is going to be my own conjecture, but I'm going to give you my theory on why Atari decided to sue, because I think there's a few different reasons. The first reason is, I think that Atari did not want their fans to think that they had greenlit this ad. I think that was one of the reasons. Insurance companies don't exactly have the best reputation. Insurance companies do not exactly typically make us feel warm and fuzzy on the inside. Whereas you think about a brand like Atari that is associated with fun, it's associated with games, it's associated with retro, warm nostalgia and colorful worlds. And that pairing feels, it feels kind of awkward. It feels kind of off. And I think that Atari did not want their fan base to think that they had approved something like this, that they had greenlit it, that they were on board with it, because Atari has a brand to protect. They have a reputation to protect. They have an image, an aesthetic to protect. And I think that probably they saw this ad and they thought to themselves, that is something we would have never approved, and we do not like that this exists out in the world. So I think that was, again, my conjecture, but I think that was one reason. I think another reason is because Atari has a licensing business to protect. So I've talked about trademark licensing before on this podcast, and you should definitely go back and listen to that episode if you haven't heard it. But licensing is a way for you to say, okay, my brand has value just kind of on its own. My reputation, the way that my brand makes people feel, it has a certain aesthetic or it has a certain emotional value. And I can actually monetize that all on its own without having to directly make new products or offer new services on my own. So for someone like Atari, they allow other people to make kind of Atari inspired products like Atari tennis shoes, for example, that I'm guessing Atari doesn't actually make themselves, but they allow someone else to use their brand, their fonts, their name, and that's another revenue stream for them. They give that permission, that company pays them royalties, everybody is happy. So Atari has a licensing business. Now, if somebody like State Farm is allowed to kind of leapfrog over that process, if someone like State Farm can use Atari products or Atari intellectual property without going through that process, without paying the licensing fee, without paying the royalties, well then why should anyone else bother paying Atari, you know? Why should they bother if State Farm's out here doing it for free? So they have a licensing business to protect. If you're going to be in licensing, then you need to do a certain amount of work to show your licensees that you are protecting their investment and that things are fair and that everyone who's going to use your brand is going to pay for it, because if not, then why should they pay for it, right? So they have a licensing business to protect. And then lastly, I think that they went through an analysis, kind of like the analysis that I described for you guys when considering that Janelle Monáe music video. I think they went through the analysis and decided, okay, we think we have a copyright claim here. Because according to Atari, they own the copyright for the art that appears outside of that particular arcade game. And they also own the copyright for the characters in that game, which also are featured in the artwork. So I think that when they did the analysis, they decided, we think we have a copyright claim here. And oh, by the way, copyright, if you successfully bring a copyright claim, the money damages potentially are very, very high. So if you have a viable copyright claim, copyright law definitely makes it worth your while to bring that claim. And so for all of these reasons, this is just my theory, but for all of these reasons, I think Atari decided that it was worth their time, worth the effort, worth their money to bring this lawsuit. So what does this mean for your business? What does this mean for your advertising? Well, you do not want somebody else, whether it's someone as big as Atari or whether it's any other person or business owner, you don't want to create a situation where somebody else sits back, thinks about it, and decides, suing them is worth my while. You don't want that. You never want that. And so, what does it look like for you to know and recognize the signs and kind of mitigate the risk in these situations? Well, first, I think that it's important for your team, your marketing team, most likely in this situation, to recognize that if you're using anybody else's intellectual property or products or brand in an ad, that is a red flag. That means that we at least have the potential here. There's at least the potential that there could be an issue. And it's important for your marketing team to understand what's okay and what is not okay when using somebody else's IP. Now, the nitty gritty of these rules would take a long time to talk about, and it's beyond the scope of this episode today. But to hit some high points, there are certain things that are allowed. For example, one thing that is allowed is something called comparative advertising. So, for example, if your competitor makes an energy drink that keeps people awake for 3 hours, and you have scientific, objective evidence showing that your energy drink keeps people awake for twice as long, it's okay to say that in an advertisement. That's called comparative advertising. Now, there's a ton of rules around comparative advertising. You do need to have scientific backing for it. The comparison needs to be objective. It can't be misleading. You can't conveniently leave certain facts out. You can't make it seem like you're comparing similar products when in actuality they differ in some key way. There's all kinds of rules, and this goes to why it's important to be partnered with a great law firm. But there are certain things that are okay, and one of those things is called comparative advertising. Another thing that can often be okay is, let's say you're filming the ad, but you're filming it in a public place. And so, yes, in the background, at a distance or kind of blurred out, maybe you can see some, signs for other businesses and things like that. But it's not intentional. It's not the focus. It's in the background. Better yet, it's blurry. You can barely read it. It's just kind of there in a very unintentional, almost accidental kind of way. Context matters for situations where you are filming in public. Context does matter if you're in a public place, and your motivations might matter, why you chose that particular spot. But that's typically the kind of activity that's going to be less risky overall. Now, if your team takes a look and there is somebody else's intellectual property in the ad, there's somebody else's brand, somebody else's product in the ad, and it is recognizable, then that would be the next level of red flag. The first level is, does it have somebody else's IP? The next level is it recognizable? And I think the challenge here for companies is to be objective about that assessment. Because you would think in a 6-second ad, the ad that State Farm ran was only 6 seconds long. You would think, oh, that's so quick, that's so short. How could anyone recognize that Atari's game was in this ad? Well, apparently 6 seconds is all it took for Atari fans to be able to recognize that game. So I think it can be hard to make this assessment objectively, but if somebody else's IP is recognizable, that is the next level of red flag. And at that point, there are two potential paths to take. And one path is a very simple fix. This is something that State Farm could have done in this situation, which is to just have made their own prop. They didn't have to use, it looks like they used an actual real Atari video game cabinet. They didn't have to use a real cabinet. They could have just made a prop, put their own original artwork on it. Boom, problem fixed. Now, if you're in a situation where the ad kind of centers around that product, or the ad kind of centers around that brand, or that feels really key to the story you're trying to tell, well, then if you're starting to feel like, no, it has to be this thing, well, then that is probably an indication that you need to think about going and getting a license. You need to think about going and getting permission from the brand owner, from the company, who actually, if it's so central to the story, if it's so central to the ad, if it's so crucial that it be that brand specifically or that product specifically, then that is a healthy indication that you might need to go out and get a license, that the safest thing in this situation is probably to go out and get permission. All right, guys. Thank you so much for watching. That is all that I had for you today. Again, this lawsuit is still ongoing. We'll have to see if they decide to settle or take it all the way to trial. But I hope this has been helpful for you thinking about your own company, your own advertising, and the ads that your team is putting together. And I hope I've given you some good tips for your marketing team to be aware of when they're trying to decide what to greenlight and what to pause and say, we might have a red flag here. So thank you guys so much for joining, and I will see you next time. Bye. Hey, thanks for listening to the show. The Legal Upgrade Podcast is a Bevel Law production. For more information about the Legal Upgrade, you can follow on Instagram at Bevel Law or find even more information on the website bevellaw.com. If you enjoyed the episode, please remember to subscribe, leave a review, and share it with a friend. See you next time on the Legal Upgrade Podcast.